siku ya leo. Hivyo basi hizo ni picha za moja kwa moja, lakini nije kwako Kathy. Kuna ambao wana mtizamo tofauti. Wanasema masuala ambayo naibu wa rais aliweza kuzungumza siku ya Jumamosi pengine yatatoa mwongozo tofauti, maanake inaonekana kana kwamba hatma yake kisiasa hata ukiangalia kutoka kwa mdosi wake, ukiangalia pale bungeni, hatma yake tayari imetolewa. Na pale tulimwona akisema hana hata usalama, tulimwona akiendesha gari lake la nyumbani pamoja na familia yake, akisema maisha yake yapo hatarini. Pengine hiyo itakuwa ni ishara ya serikali kuonekana hawana nia njema ama hawafuati sheria kikamilifu kuweza kumruhusu aendelee kupata yale anafaa kupata kama naibu wa rais aliyeng'atuliwa hadi pale atakapoondoka rasmi.
Sasa Lois, nafikiri kitu ya kwanza ni vizuri tuelewe kuwa huyu si naibu wa rais tena. Huyu ni naibu wa rais aliyeng'atuliwa. Na kwa hivyo kuna privileges ama kuna yale mambo ambayo alikuwa yeye mwenyewe ya kulindwa na kuwa na wale watu ambao tumeona tukaangalia tukaona ni karibu 100 na kitu ambao walikuwa kwa ofisi yake na mambo kama hayo na mambo mengine tofauti ambayo kwa sasa haezi kuwa yakimfuata. Na sasa hiyo pia ni kitu ambayo sisi wengi ambao wanaelewa siasa tulikuwa tunagoja ifanyike, kwa sababu lazima ingefanyika ndio apatie fursa ule ambaye anakuja kuchukua ile nafasi kukuwa na yale kukuwa na zile privileges ambazo naibu wa rais anafaa kuwa nazo. Lakini umeniuliza swali ukasema kuwa ile mambo ambayo aliongea siku ya Jumamosi, yale ambayo ni Jumapili nafikiri, yale ambayo aliyaongea pia kusema kuwa hakuweza kwenda sherehe za mashujaa na mambo kama hayo, mimi nitasema ni katika ni tabia ya aliyekuwa naibu wa rais kwenda kwa wananchi, kupeleka mambo yake yote, kupeleka kilio chake, kupeleka maneno na pia kwenda kuonesha raia kana kwamba anagandamizwa. Na hii tumekuwa tukiona tangu ile wakati ambayo hii kesi yake ilienda katika bunge la kitaifa. Na kwa hivyo mimi hata zile vitu ambazo waliongea si kuona kama ameongea kitu geni, kwa sababu ni tabia yake ya kwenda kujaribu kucheza na hisia za wananchi. Lakini ile kitu jambo ambalo amesahau ni kuwa sasa hii si siasa, hii ni kesi ambayo iko mbele yake. Kwa sababu ikifika ni siasa unaweza ukacheza namna hiyo, na ikifika ni mambo ya kesi na mambo ambayo iko katika koti, sasa hiyo nayo ni tofauti. Kama mimi angeniomba niwe advisor ama mimi nimpatie ujuzi ama nimueleze tu kile ambacho angeweza kufanya, ningesema ingekuwa vyema kama angenyamaza, angoje vile mahakama itaamua na aonyeshe kuwa pia yeye mwenyewe kama Mkenya wa kawaida, kama Mkenya mwingine, anaheshimu koti.
Naam, Steven, tunakuja kwako muda si mrefu na ningependa tuongelee ikiwa kesi hii itaweza kuondolewa. Je, itakuwa ni mtizamo upi ama mabadiliko yapi ya kisiasa ya uongozi hapa nchini Kithure Kindiki atakapoapishwa? Lakini mtazamaji wangu, kabla ya hapo naomba tuelekee majimboni, kaunti ya Nakuru, ambapo mwanahabari mwenza Ruth Sarmei yuko tayari kusema na wana Nakuru. Sarmei, kuna unanipata uwanjani wako? Wa Kenya kutoka kaunti ya Nakuru wanasema nini kuhusiana na hali ya mshike sheria na siasa wiki hii na hasa
Yes. Tom is not here.
Gracias.
Inafika hapa tu. Hapa no. So it's
Good morning, everyone. His Lordship, Justice Eric Ogola, His Lordship, Justice Anthony Mrima, Her Ladyship, Justice Dr. Gibiru Frida Mugambi, for HCC Petition E565 of 2024, regarding Gachagua versus state law.
My Lords, Your Ladyship, in petition number 565 of 2024.
Why do you have two counsel standing?
Good morning, my Lord.
Good morning.
Principal Presiding Judge, my Lord Justice Murima, and my Lady Judge. I am standing as the Attorney General, and I was going to address you pursuant to Attorney General's Act Section 7, which provides that I take precedence. May I have your advice?
There is no objection. That is the correct position.
Thank you.
So,
we will take the quorum.
yes, I was going to request you that we take the quorum first. I'm Dorcas Odora, Attorney General, Senior Counsel. The Attorney General has also been sued as a party, and therefore representing the Attorney General is Professor Gibi Mwigai, Senior Counsel, Shadrach Mose, the Solicitor General, Emmanuel Bita, Deputy Chief State Counsel.
Emmanuel who?
Emmanuel Bita.
Where is he?
I'm present, also.
He's been swamped. And Charles Mutinda, Deputy State Counsel.
Present, my Lord. Present.
For the National Assembly, we have Eric Gumbo,
I'm present, madam.
Paul Nyamodi,
Present, madam.
and George Murugara.
Present, madam.
For the Speaker of the National Assembly, we have Benson Milimo,
Before you, my Lord.
Josephat
Just
Kuyoni.
too fast.
Oh, sorry.
We introduced Mr. Mugara for.
Mr. Murugara George for National Assembly. For the Speaker of the National Assembly, we have Benson Milimo,
Present, my Lord.
Josephat Kuyoni.
My Lord, I'm present.
Just for who?
Kuyoni. Kuyoni. For the Senate, we have Professor Ojenda Tom, Senior Counsel,
Present.
Moni Mukele Edwin,
I'm present, madam.
and Senator Hilary Sigei.
I am
No, Money who?
Moni Mukele Edwin,
And Professor?
and Senator Hilary Sigei. That is for the Senate. For the Speaker of the Senate, we have Mercy Tanji, and Peter Wanyama.
I'm present, madam.
For Professor Kindiki, CS, and DP nominee, we have Mudomi Piankolu,
I'm present, my lord.
Moses Kosgei, and Ken Meli.
Present.
My Lords, your leadership, in Petition 565 of 2024, may I, at the very outset, before I state counsel appearing as the Deputy President applicant, may I, at the very outset, say that I am stating the quorum under protest. We are not willingly here participating, we will elaborate. But let the record show that counsel appearing for the Deputy President today before this honorable court appear under protest. As I say, the basis will be elaborated later. I appear for waiting for the record. I appear with my colleagues, Tom Acharya, Elisha Ongoya, Faith Waigua, Victor Soanya, Tego Wanjiru,
I am present.
Andrew Muge,
This we are recording the quorum. Faith Waigua,
Faith Waigua, Victor Soanya Ogeto, Devo Wanjiru,
I am present.
Andrew Muge, George Wandati, Mr. Sakim Pa, and John John.
Present, my Lord.
My Lords, your leadership, as I sit down, I seek clarity on whether it is only Petition 565 of 2024 that this honorable court has before it today, or whether there are any other petitions. I thank you.
We will take quorum on all the files that are before the court first.
Petition E015 of 2024 at Kerugoya. Petitioner David Muni Mazenge and 4 others versus the National Assembly and 5 others.
May it please your lordships and my lady judge, in E015 of 2024, the quorum for the respondent is the same, save for His Excellency the President, who has been sued in person and is being represented by Adrian Kamodho.
Just for the purposes of clarity, just will record the quorum fully.
Dorcas Odur appear as the Attorney General. For the Attorney General is Professor Igai, Senior Counsel, Shadrach Mose, Solicitor General, Emmanuel Bita, Deputy Chief State Counsel, and Charles Mutinda, Deputy Chief State Counsel.
Your Lordships and Your Lordship, my name is Kipe Mungai, appearing in this matter with the following. My Lord, in this matter, I appear with Senator Daniel Manzo.
Your name, please.
My name is Kipe Mungai. I thought I'd sent it to you. Kipe Mungai. I appear in this matter, my Lord, with Senator Daniel Manzo, Mr. Ndegwa Njiro, Honorable Jerry Maina, Mr. George Sankimpa, Mr. Andrew,
Mr. Kipe,
yes,
we are recording the forum. Yes. Can you start from Dan Manzo?
Dan Manzo, Mr. Ndegwa Njiro, Senator Honorable Jerry Maina, Mr. George Sankipa, Mr. Andrew Muge, Mr. Gachagua, and Mr. Kenneth Matiba, who is on the way, and Professor Ogada.
Professor Ogada, present.
And Kenneth Matiba is on the way. My Lord, we appear in this matter that continues to be referred as Kengoya, petition number E015 of 2024 that appeared to have been filed on the same day
So you appear for which party?
We appear for the petitioners.
Lords, your leadership, this petition E015 of 2024, the Kerugoya file. Again, we appear for the first interested party, that is the Deputy President of the Republic of Kenya, in this E015. The Lords, again, let the record capture and show that counsel appearing for the first interested party appear under protest. Counsel as follows: Paul Mwite, Thomas Maria, Elisha Ongoya, Faith Waigua, Victor Soanya, George Wadati, and John.
Can we have that again?
Yes, I'm sorry. From what point, my lord?
From yourself.
Paul Mwite, Tom Macharia, Elisha Ongoya, Faith Waigua, Victor Soanya Ogeto, George Wandati, and John Job. At the appropriate time, we will be going into the grounds and basis for appearing under protest. Like that.
My Lord, before there were also certain clarifications that I would like to be given before the hearing for today. Direction for today's hearing can be given.
In which
My Lord,
My Lord, before Mr. Kibe moves on that file, are there other files, especially file number petition E572 2024? Is it before the bench? We'll take quorums on the files which are before the court. About that, you can raise any issue.
My lords, may you kindly equally confirm whether E509, which was consolidated with E522, is before the bench. One reason, Your Lordship, is that the bench was specifically constituted for that purpose.
Petition E13 of 2024, High Court of Kerugoya, Thomas Kimotho Maingi, petitioner versus Deputy President of Kenya, respondent, and the Honorable AG.
My Lord, that matter is not before the court.
Your Lordship, if you call, it is the court that should know whether it is before the Attorney General.
We had a notice.
We also want to know whether it is before this court.
My lords and my ladies, kindly, with your kind permission, I would also want to seek clarification for my own petition which I have filed, petition number E567. I had information that that file was also coming up before you this morning, and I would like to know whether the same is before you, and if so, whether we can also proceed with it.
When was it filed?
It was filed on the 18th of October 2024, and it came up before Honorable Justice Mwamuye, who gave directions that it should come up actually tomorrow, and I believe that is part of the reasons why there is protest in this matter. And then I was informed that it's coming up today, so I also need clarification.
To please the court. My name is Dr. Eboso. I'm a petitioner in E541 of 2024, a petition that was filed on 8th of October, and a petition in which we got directions on 16th of October, directing that it be brought before the Chief Justice for this bench. It raises the same issues as the issues that were consolidated, and I'm appearing in person with Ms. Ivy Mwangi, the second petitioner, and we were seeking clarification with regard to directions on that file, because as we can see, there are files that were filed on 17th of October, and which directions were given, and the bench was constituted. So we expected that the matter would be mentioned together with this one today. Thank you.
Lord, with utmost respect, this honorable court is a court of record. And the record is very, very important. My Lord, Your Ladyship, we heard the court assistant call out petition E13 of 2024, and she mentioned the word Kenyan. That is the file that was called out. And in order for the record of this code to be systematically accurate and easy to follow, may I with respect ask that we get clarity on this file that was called out, E13/24 of Kenyan, before we go to the other matters. And perhaps it is for this honorable court to clarify which files, one by one, are before this honorable court.
Senior Counsel Paul Mute, we are giving you time to talk. You see, everybody wants to talk. There will be a time for us also to talk. So I've heard you.
Thank you.
For this morning, for the purposes of hearing this morning, the applications which are before the court are application number E0113, which was consolidated in Kerugoya before it arrived here, with E0114. 0114. Then we have application number E0115, also from Kerugoya. That is application before this court. And then we give direction on those applications. And then E565. Those are the three matters which are before this court and in which the Honorable the Chief Justice has constituted this bench for hearing and determination. If you there are articles of constitution of this bench in record. So the three matters before the court are E565, E015, E0113, and E014. Those are the files and petitions, applications before this court. And those are the applications on which this bench has given directions pursuant to this bench being duly constituted. So any other applications which you are talking about, we have not cited them. Maybe they are yet to reach us, but for the purposes of today's hearing, we have these three petitions or applications.
Your Lordship, we are well guided. And perhaps also to state for record that we also appear in E015 in protest. But further that, Your Lordship, kindly confirm that the number that is now registered in the matter that came from Kiruguya is E015. And that is important, Your Lordship, because of the purposes of administrative transfers of files. Because what was at Kiruguya, Your Lordship, was E015. Does it therefore mean that that file has not yet been integrated into the Nairobi files? And if so, then how do we appear to proceed before you, and how was the matter that we shall raise other issues? Just confirm on the question of the integration of that file with the Nairobi files, because the last file that we have should be 565 as at Friday. Are we dealing with the matter in Kiruguya or in Nairobi?
Yes. Let me deal with that. My Lord, for the purpose of E572 of 2024.
That file is not before us.
That's all I'm only saying. I have heard the directions of the bench. The file is not before you. But I have instructions for the purpose of the work to check that that petition was filed on 18th of October. The same day the Kiruguya file were filed. All the directions in all these files that have been taken to a graveyard is that none of these files of ours have orders. The reason as to why Kiruguya file is before the learned judges is purely because they have orders to stop the swearing in of the deputy president-elect. The CJ could not have selectively decided to have only one file before you, my lords. This is a trial of the judiciary. It is a trial that goes to the root cause of whether there is impartiality.
Mr.
Yes, my lord.
Mr. Omari.
Yes, my lord.
The file you are addressing us, we have said, is not before us. And the files which are before this court are the files in which this specific bench has been empaneled.
Thank you, my lord. Allow me to mourn. Because the questions I'm raising are very pertinent, that there are files selectively brought before you.
Mr. Omari, we wouldn't know that because, as you understand, we only deal with matters in which we have been empaneled. We do not empanel ourselves.
Thank you very much. The empanelment authority has heard me loud and clear. Thank you.
And my lord, if you could mourn elsewhere.
I have indicated to this honorable court that there will be at least 3 clarifications.
Just a minute, Mr. Mugwe.
I think we need to get some things right. I want to clarify how these files are before this bench this morning. The 3 files which were filed in Kerugoya, that is 13, 14, and 15 of 2024, had some interim conservatory orders issued by the court. Further to the issuance of those orders, the learned judge made further orders requesting the Honorable Chief Justice to internal a bench. Those files were transmitted on the basis of that order to the Honorable Chief Justice's office on the 18th of October 2024. On that very day, the Honorable Deputy Chief Justice empaneled this bench to hear those matters. Thereafter, applications were filed online. I think you are all aware that we are operating online. Applications were filed online. When those applications were filed online, those are the ones which this bench gave directions for these matters to appear before us today. That is why you are here, and that is the trail, that is the paper trail as to why we're here this morning. So I reiterate the position taken by the presiding judge that we will not be comfortable dealing with any other file, even if it's related to this file, which we did not give directions for it to appear here today. So I think we can now proceed on the basis of that clarification.
Thank you, Judge.
My Lord,
just a minute, please.
Perhaps just to add that the numerous other petitions that are coming up, I think the process is ongoing. Maybe not all the files have been transmitted to the bench. Maybe by the time we leave this courtroom, other files will have been transmitted to the bench. But as we speak now, here and now, these are the only files that were transmitted to the bench and in which there are applications where the bench gave directions for hearing today. That is not to say that those are all the petitions there are. We don't even know whether the transmission has been done yet, and that we will go back and find all the other petitioners whose concerns are valid. Perhaps those files would now be before the bench formally so. Right?
Yes, my Lord, I believe now I can be able to make the clarifications. We are starting with the immediate background that we need to make these clarifications, and we take...
No, let us finish with quorum first. There's the quorum there's a quorum in E013, which was consolidated in Kerugoya with E014. Let's take quorum on that file.
There's something wrong. Your Lordship, is terribly something wrong. And I believe it is important for us to put things into proper perspective. Because when you call the matters, E13 was not part of what was called. I have not heard it, perhaps it would be called. Your Lordship, in E015, there has never been a consolidation. To the best of my knowledge.
Why are you talking about consolidation? Nobody has talked about any consolidation. These files have not been consolidated. I think that is the next process we'll be going into. Nobody has talked about any consolidation. If you look at the record, you will find that the directions for today's hearing are given specifically on each and every file. There was no consolidation of any matter. No matter has been consolidated. So let us not dwell on things which really are not before the court. Now matter has been consolidated, and let us proceed from there. If you want to apply for any files to be consolidated, that is okay. As we speak now, there is no consolidation. The directions from this court were very specific on 3 different files.
My lords, I'm more guided, but when Justice Murima was giving the clarification, I never heard him clarify whether the Kirogoya file has been integrated into the Nairobi system. Because we cannot be dealing with a file that is reading Kirogoya. Because of course, if there is no integration, Your Lordship, then there is a rat that is made.
My Lord, may I say something?
Let me answer him. You said that record speak for himself. And for record, matters which came from Karigoya came with their own record. And the record states here that the matter herein is consolidated with Petition E014 of 2024 and the same to be delivered in the Chief Justice for empanelment of bench in terms of the ruling in Petition E014 of 2024, a copy of which shall be placed on this file. So your own matter coming from Karigoya was already consolidated. Those proceedings which took place in Karigoya consolidated these 2 files. So let that not be an issue here, please. On the directions issues on 11th by Judge Richard Mwongo, these were the directions. The petitioner in E014-2024 to serve their amended petition on all parties. Similarly, the petitioner in E013-2024 to serve their petition on all parties. Respondents to the petition to file their responses by noon of 17th of October 2024. Given that the files are being routed to Honorable Chief Justice forthwith, the parties' response to the amended petition and petition E013 of 2024 may be filed in Karigoya under the Karigoya case tracking system online, whereupon they shall be forwarded to Nairobi. So these proceedings took place in Karigoya. So this court has not consolidated any matter. Petition number E014 and petition number E013 are hereby consolidated. The parties who appeared before the Karigoya court were given those orders. Those were your orders.
And with your permission, Presiding Judge, the reason why Nairobi has not opened another file to put together all the files from Karigoya is this. Going by the orders which were issued by Karigoya court, there was a specific order that because of the transmission, parties will still file their documents under the Karigoya CTS, that is the court tracking system. We had to hold on to that so that not to disadvantage any of the parties until we appear today. Those are some of the things we will deal with here and make orders to the Honorable Deputy Registrar to formalize that. So there should be no cause for alarm. We will put everything into its place.
I presume we may now raise the issues that one raised, particularly arising from the issues in Karigoya.
We will then proceed and take quorum on they were consolidated, so we will not take further quorum on this matter.
The Attorney General, I don't know, I have indicated to the court that I need to raise some clarification.
Section 7 of the Attorney General's Act.
You can read your subject. It doesn't override my right to represent my client.
I'm repeating it.
Can she then say her piece? I say mine.
Which matter are we now dealing with?
We have 0115.
We have several.
We have 0115.
My Lord, I wanted to say that
yes,
the only matters before this court are the matters which had ex parte orders. The matters that came from Karigoya E13 and E14, although consolidated, they were filed before impeachment and they have no conservatory orders.
We have
E15.
E15 has
conservatory orders, but E13 and E14, although from Kerugoya, they were filed before impeachment and they had no conservatory orders.
I hope and then we have my Lord, I'm leading the number of advocates in this matter from Kirinyaga is 0.
Kerugoya 15.
Yes, Kerugoya
15.
Yes. My Lord, the clarification that I seek to raise emanates against this general background. The first one, my Lord, is that there was a sitting on Saturday, which the court has since explained how that sitting occurred. With regard to that sitting, my client wrote a letter to the Honorable Chief Justice, which has been placed on record in an affidavit, in an application before you, that protesting, amongst other things, that the practice in which a Saturday sitting would be convened for purposes of hearing the executive and organs of government that have violated fundamental rights is a practice that is prohibited under the 2010 Constitution. That is we did not trust that the Honorable Chief Justice could actually do that because she knows the history about what used to happen. But we now learn, Your Lordship, that you are convened by the Honorable Lady Justice Willing, the Deputy Chief Justice. My Lord, arising from that are one, a legal issue and a matter of Article 150. My Lord, under the law, and we do this every day, I practice public law every day. Arising from that issues of the communication, speaking for 015, we expected that the general procedure would be, and that is what the orders implies, and required us to come on Thursday this week, that when the Chief Justice appoints a bench, she will do it in writing as required under Article 47 of the Constitution. We will be given the number of those judges and the day that they will be sitting. This day, we have not received officially, because even when the sitting happened on Saturday.
My Lord, may
I think I have a right to raise those issues.
Professor Mugai, just give we have Philip Mugai time to.
I just wanted for good order, okay, my Lord,
is that
if I may.
Clarification, Mungai.
Mugai. My Lord, I am Mugai. I believe he will speak in response as soon as
proceed.
My Lord, I wanted to assist the court because my learned friend has, I believe, filed a substantive application so that the court does not hear speeches in vacuo. My learned friend should identify what application he is ventilating so that even we taking notes know what we should be responding to. That's all I wanted to say.
Professor Mugai was a former Attorney General. I respect him. He was also my teacher, my professor for criminal law. But my Lord, the point that I wish to make is that I am acting for specific clients today, and that's the court. I should be heard in silence. He will respond. And I indicated that we have formal applications. What we are raising is an issue that is arising from what Judge Murima has indicated. We could not put it earlier in an application. So if I may proceed, my Lord, the issue is this, that we expected a notification in writing that these judges have been appointed and they would sit on a particular day. All those notifications including in cases of abductions, have been that the first sitting by a bench has been on a working day. All applications, and I'm aware of this as a fact. So then the first clarifications would be, on what basis would, in an application by the executive, be convened on a Saturday? That is a substantive issue because of the second reason that background that we are giving. But under the 2010 Constitution, the constitutions provide for the Bill of Rights. My lords, under the former constitution, under the former constitution, we used to have a practice in which we had unofficially a bill of immunities for the state, where the constitution, the state could conduct its business on weekends and outside court sitting hours. But because of that reason, that's why I'm saying, this, we are sitting here pursuant to the orders made on a Saturday. And my lord, we are also sitting here pursuant to an order made by the Honorable the Chief Justice. My lord, for purposes of Article 165, I believe it's 4, of the Constitution, the powers of the Chief Justice to appoint a bench is a substantive power. It is not administrative. This power, my lord, cannot be shared by the Deputy Chief Justice or with the Deputy Chief Justice. And because it cannot be shared with the Deputy Chief Justice, it is the reason why I say two things. That our instructions is that we must move this court immediately to set aside that order on the basis of its unconstitutionality. The Chief Justice of Kenya cannot appoint anyone, any judge, pursuant to Article 165(4) of the Constitution. And we shall place here the Deputy Chief Justice a formal application. Issue number 2, my lords, arising from that.
You imply that we discharge the directions of empanelment.
My lord, I am saying that we shall make a formal applications to discharge that order made by the Deputy Chief Justice. That's what we are indicating. My lord, number 2, and it is implied in the applications for disqualifications that we have filed. Number 2 is that we raise the issue that for purposes of the Saturday sitting and today's sitting, and the thing is out there in the streets and the Republic of Kenya, is that a special bench would be appointed for purposes of vacating the orders that we have made. But I have a lot of respect for all of you that have appeared before previously. But my lord, pursuant to my instructions that that would be the case, 3 issues worries us. Number 1, we had a sitting on Saturday, the practice of the former constitution, where the executive enjoyed special privileges. Number 2, my lord, is that we have confirmed that the only files that are before you are files where we have interim conservatory orders. So that, my lord, and it is important that this issue is speak for the 190 and with a clear conscience. 2 things. But the first thing would be this, that if this matter is going to be conducted like today on the basis that only those matters where the Attorney General is itching to set aside conservatory orders are the ones that are going to be heard, there would be something wrong because other cases that are even officially before you and probably assigned to you by the actual Chief Justice of Kenya are still pending. So what was this where you prioritize the state as it used to happen those days before we had a new constitution? Issue number 2, my lords, is this, the issue of bias. And this is biased by the Honorable
I think, Mr. Mugai, you are going beyond ordinary comments. If you have an application which addresses those prayers or those issues, I think you better...
There is another issue that yes. Does not have to do with those things. Well, the last issue, therefore, would be this. If assuming that cases that were supposed to appear before you are cases that came after the impeachment, my Lord, there are about 4 matters. One of them in which I appear. And this is a fundamental issue. That matter is coming on Thursday. Okay? An express order of the court that has not been set aside. The question would be this: for purposes of good order and for purposes of us making this application, why would it be difficult even for this bench to order all cases, because that is the right to equality under Article 27 of the Constitution, that deals with the same subject matter, come on a specific day where all parties have notice, so that even the issues that we are raising against the Deputy Chief Justice can be formally put on record, so that we do not have this anxiety that somebody is speaking off record. But Lord, why I say as I go to see, why I say this is important is this: the matters before you over and over again, the repeated question has been, the right to fair hearing is being sacrificed. Under Article 25 of the Constitution, fair hearing cannot be taken away even during an emergency. It is an absolute right in this country. So that, my Lord, arising from that, the question that we would like us to be addressed is that to say that we are going to conduct matters by installment, and the only justification for the chosen installments being that the Deputy Chief Justice is biased for the state and has therefore constituted a bench that can be able to hear the state's application, is clearly not permissible.
Mr.
So that may not
I would not, please, we should not bring the DCJ conduct at this stage, because I think that the DCJ discharged her administrative duties the way it should be done.
That is
but if you have an issue with that, please don't make a generalized complaint.
Well, this is not generalized. It is in writing, and we are making a formal application to ensure everything is done on record. And that right, as I sit down, the issue of that right is that we have had a situation before the National Assembly, before the Senate. It didn't seem to matter. Before the High Court, my lords, I submit the right to fair hearing under the Constitution must count for something. Otherwise, Article 25 would effectively have been amended to please the state. I urge you respectfully.
We hear you.
My lords, just to add on what my learned friend has submitted on.
Just a minute, please. With the permission of the presiding, I wish to say that I wish to make this clarification. The matters which are before us today, the 3 matters which are before us today, are not here on the basis that some conservatory orders were issued per se. I have stated and I'm repeating. The reason why these matters are before us today is that after the issuance of the conservatory orders, subsequent applications were filed. The applications were filed after the empanelment. Those applications were filed online. We deal with matters online. And it is on the basis of only the applications which were filed and dealt with online. That is why we are here today. So I want to correct the insinuation that we are here only to deal with the matters in which conservatory orders were issued. We don't know how many conservatory orders were issued. We are only here to deal with specifically the applications which were filed, which came to our attention. So kindly let us be as factual as possible We will deal with all the matters. I can assure you, there is no issue about any of the things you are raising. If you have any substantive issue, we are here. If application for recusal, there is no problem. We will hear. If we feel we have to get out of this, there should be no problem. We are all here to defend the Constitution of Kenya. So don't you worry. Don't you worry. Give us time. Let's take this thing step by step, and we will do the best we can as a bench.
Allow us to worry when we have grounds for worry.
Senior Counsel Mwite and Counsel Ndegwa, you know, when you argue like the way Mr. Mugabe has argued that court start on Saturday, you are arguing on both sides of the court. You know that we work online, and most of you know that matters reach us anytime, whether at night, and that is what the new constitution and the e-filing system has brought to this country. So when you argue selectively, you mislead the people. You mislead the people outside there that courts start on a Saturday. There's nothing like that. We attend to matters online as and when they come. But we have had Mr. Mugai. Let it not be an exchange between the court and yourselves, because we are really very neutral party. Let us hear also from the other side.
We haven't finished. In E015 in Kiruboya, the deputy president is the second respondent, first respondent in fact. We haven't said our piece, and Elisha Ongoya will be making submission. But my Lord, do give us, these are very weighty matters. This E015 in Kiruboya, the orders of your brother, Mr. Justice Mungo, were given 4 p.m. When did the file come from Kirinyaga to go to the Deputy Chief Justice? It is 2 hours drive from Kirinyaga. When did the Deputy Chief Justice sit in the middle of the night on Friday to give directions? Permit us to articulate these issues for the sake of the nation. We're not just dealing with the removal and the challenge to the removal of the deputy president. We are dealing about the president that will be set for the removal of deputy presidents in future and the removal of presidents in future. Elisha.
My Lord Presiding Judge, I want to renew my request that the court permit us to be orderly. We are now about to hear a second speech, a third speech, a fourth speech. This court, as we have been told by the senior most advocate here, is a court of record. What application are we hearing so that we on this side can prepare to respond? We cannot respond to speeches. There is an application here, if I may, the Honorable P.K. Mwite. There is an application for the recusal of judges. It is the right of my learned colleagues to bring such an application. But having brought it, they should then confine themselves to it. Then we can respond to it. But we cannot sit here the whole afternoon listening to speech after speech intended for another audience other than this court.
There's no other audience.
Let us be clear on this. The applications before this court, we have stated which applications are in this court for hearing today. We have no authority to call any other file, because files, when there's a prayer for empanelment of a bench, those files go direct to the Honorable the Chief Justice. So we have no authority to call any other file to ourselves. That will be quite procedural. So what we have here are the 3 files which we mentioned, in which there are interim orders where one party is seeking to lift those orders. If there is an application for recusal or whatever it is, I think you really need to put it on record so that we deal with it, and before any other thing, we can deal with it and dispose of it one way or the other. But I don't think it's really necessary to have speeches in the absence of specific application and prayers.
Your Lordship, the so-called speeches have been invited by the disclosure from the court. We, the advocates appearing for the petitioners, we were not aware of how the bench was constituted. So when it was disclosed to us that the bench was constituted by the Deputy Chief Justice, it necessitated us to address you, Your Lordships, on Article 165, Clause 4. On the constitutionality of the constitution of this bench to hear these three specific files. And that is the issue that we want to address even before we go to the application for recusal. Because it's our humble view, Your Lordship, that the so-called empowerment of this bench to hear these specific files is itself unconstitutional. By the reading of Article 165, Clause 4, it is our reading that the only person who has the capacity to empanel a bench is the Chief Justice. So we want to urge this court to perhaps interpret for us whether the Deputy Chief Justice can empanel a bench. Number two, Your Lordship, is where did the Chief Justice get the authority to empanel the bench? Was the Chief Justice present? Why did the Chief Justice execute her functions and her mandate under Article 165 Clause 4? What was the necessity of the delegation of this function? Those are pertinent issues, Your Lordship, that requires clarification before we go to the root of the matter, the crux of the matter. It's our submissions, Your Lordship, that the Chief Justice, who is exercising delegated powers, cannot further delegate the Deputy Chief Justice. That is why the Constitution is in white and black, that the obligations and the duty belongs to the Chief Justice. Finally, Your Lordship, the reason why we find ourselves in this situation is because of what the court is struggling to explain to us. That three files have graciously generated expediency, and other files that were consolidated, that 6 file with the lead file 522, have no reasons why they should be before you. Noting that, Your Lordship, those matters were equally certified as urgent and raising heavy constitutional matters. When I looked at your orders, Your Lordship, that you issued to serve on us today, you repeated the same, that they raise weighty constitutional matters. Why are we being discriminated by the court that our files are not considered as a priority? And the files with orders are the only ones that the court is sitting on a Saturday
and overreached the president, which in our view lies squarely within the domain of the Supreme Court. So we once accorded an opportunity procedurally, we shall ventilate all those issues, and hopefully the matters being raised or to be raised about recusal and so on, they will fall by the wayside. Thank you, my Lord.
Lord, for the fifth interest, for the first interested party.
Mr. Gora, just a minute. I was about to interject when when Council, yes, was addressing, and that is exactly why I wanted to. I wanted us to have order in the way we conduct these proceedings. And I was about to ask Mr. Ndegwa, after all that, what is your application?
Your Lordship, I'm very clear in my application. My application for which
the application can only come after I have spoken.
We are now making an application. You respond.
What is it that you want?
Your Lordship, permit me to make an application under the Mutunga rules that following the disclosure of the court this morning that was made by Justice Murima, that this Honorable Court does determine whether the Deputy Chief Justice has the power to empanel the bench under Article 165, Clause 4. Your Lordship, and whether, if she has any power of that nature, the same ought to be communicated to the members of the Republic by the Chief Justice, that is to say, Your Lordship, that the Chief Justice has delegated her powers under Article 165, Clause 4, to empanel this bench. Your Lordship, this is the background of my application, that on the 14th of October 2024, the Honorable Chief Justice did empanel this bench to hear and adjudicate over 6 matters which were consolidated with the lead file being 522. And the files that were consolidated, Your Lordships, my lady, were 522, 509, 537, 528, 525, and 506. Your Lordship, it is our humble submissions that this bench was exclusively empaneled to handle those files, and that the communication was effectively made to the parties by the Honorable Chief Justice. I am giving the background of my application, and that we are aware that subsequently other files, and the most important one is E014 of 2024, which came from Kerugoya, was equally slated for empanelment before the Chief Justice. To date, Your Lordship, there is no communication from the Office of the Chief Justice other than this morning that this file was equally empaneled and designated for hearing by this bench. Your Lordship, the other ground is this, Your Lordship, that when we appeared before you on the 16th of October, Your Lordship, we sought your indulgence, Your Lordship, to have a further mention on the 18th of October.
My Lord, I'm sorry we are constrained to interject to seek your guidance. My name is making an application before this bench complaining about wrongs supposedly made by the Chief Justice and the Deputy Chief Justice in bringing us to this session of today. For me, the clarification I wish the court to provide is whether an application of that nature can be made informally without the CJ and the DCJ being made parties to that application and being offered an opportunity to explain, so that to be fair on these state officers, it's easy to speak to the gallery and cast all manner of insinuation and aspersions against them. And if my Lord finds that an application of that nature cannot be made informally without actually filing a formal application and joining the CJ and the DCJ so that they have a chance to respond to these insinuations, I suggest again, and I beg the court, I'm a very junior counsel, but Professor Muigai wonders that we run the risk of coming to a court of law to speak to the gallery. In parliamentary language, what I fear is happening is what is called filibustering, my lord. To filibuster is where you go to a forum intended to deal with the business of the day, and you keep making speeches upon speeches that have no bearing on the business of the day, where the motive is to ensure that the business of the day is not conducted. To the best of my knowledge, the business of the day there were applications on their side, there were applications on our side, and the court was graceful enough to give both sides an opportunity to come today to ventilate those applications. Instead, we've lost 2 hours, my lord. We have not been addressed on those applications. We are just filibustering.
My lord, perhaps if I may.
Yes.
You are being invited to interpret Articles 161 and 163, 1B, 1 and 2, which designate the Chief Justice and the Deputy Chief Justice as head and deputy head of the judiciary. And you are being asked to inquire into the manner that they perform their duties as head of the judiciary and to interpret Article 165(4). That can only be a substantive, through a substantive application to which all parties must respond. I think my concern then, and my friend Kibe, is that you are taking the court for a long ride and you are ending up wasting a lot of time in court. I wish you could go to the issues. If the question is, if you are ending up with an application for the disqualification of the bench, why can't you go to that point instead of beating around the bush, as you say? My lord, if I may, just to bring it to the court's attention, that the issue that my learned colleagues have taken up rather dramatically this morning is an issue that they have taken up with the Chief Justice by way of a letter. Before they came to court, they have taken up those issues with the Chief Justice by way of a letter. If that is the avenue that they have chosen, then let them deal with it by way of the letter. It isn't anything that should take your lordship's time. That letter remains. They have written it to the Chief Justice. We have been copied on the letter, and we await the learned Chief Justice's response to the letter. It isn't anything that should take up time this morning.
My lords, if it pleases the court, my name is Dr. Modi. I am acting in person. We filed an application for the certification of LLC on the 8th of October, 2024. Before this bench was impaneled on the 14th of October, 2024. Unfortunately, some of the pledges we were seeking have been taken by defense. My lord, as there is a heard, our application has not been placed before you, and we are just concerned that our application will once again, investment and once again overtake our application. My lords and my lady. So we're asking with the kind indulgence, if you would please at least allow us time, my lords and my lady, for our application to be consolidated and heard together with the other applications that have been heard today.
Madam Secretary, for the 5th interested party in 15, may I just be heard for 1 minute only? My Lord Judge, I ask an important question. How do we move forward? Now the paradox as I got it, because I don't make speeches, is that my colleagues accused this side of making speeches, and in the process they made speeches. But having said that, my Lord, An issue has arisen following disclosures by my Lord Justice Mrima about how this bench has been constituted. It's now apparent that the petitioner and the first interested party in Petition 15 have an issue with that. We suggest that we be given time to file a formal application. It could not have been filed earlier because the disclosure has been made here. And since that issue goes to the core of your capacity to sit, it ought to be resolved preliminarily. Whether you have been properly paneled is the most preliminary of preliminary issues. We urge that you give directions in the nature of a timeline when that application ought to be filed, a timeline when responses will be filed, then give us a return date to come and canvass that application on whether you are properly constituted. Because if it turns out that you are improperly constituted, even the issue of recusal becomes secondary. Yes. But if it comes out that you are properly constituted, then the issue of recusal now follows. I urge that if we follow that route, in accordance with my teacher's guidance, Professor Gideon Muigai, there will be greater order and coherence. And I thank you.
Is that an adjournment? Is the lawyer applying for an adjournment? Because he's saying, and perhaps rightly wrongly, that even the recusal application comes after the termination of the question when panel. If that be so, an application they normally leave court, they may leave the left Senate, may leave court. Let them say whether they are applying for adjournment.
Is that remark, they normally leave court, the left Senate, palatable in this court, my lord? I need that answer first. No, is that remark palatable before my lord and my lady? My lady, because, you know, we have decorum at the bar. If you have a professor of law misbehaving at the bar, then there's a problem. I'm urging that you direct that remark be withdrawn first, then we make progress. I'm urging, my lord, the remark was made in your presence. I'm urging it to be withdrawn first, then I can respond.
My lord, I have no problem in withdrawing the remark. But the point is, it is a veiled application for adjournment. Because Mr. Moyer is saying that the court must address the question of empanelment before the recusal.
I am answering the question now, but I know that he has withdrawn. He said he has no problem with withdrawing, but I didn't withdraw. I want him to withdraw first, my lord, because I'm entitled to dignity.
I have no problem withdrawing.
No, my lord, you must withdraw.
I withdraw the remark.
Thank you so much. Thank you. Thank you. Let me now address the question as addressed. My lord, Professor Jenda was my teacher and been my mentor of many years. I have no disrespect for him. I just want my own dignity asserted because I can't protect my client's dignity if my own is in question. But having said that, my Lord Judge Mrima, you are a witness that the issue of how this bench was empaneled has been disclosed here when we are here. We have raised concerns to learned colleagues, Kibe Mungai, and learned colleague Mr. Gachagua, that we now want to take that as an issue. My colleagues have rightfully submitted that matter requires a substantive application. Rightly, we agree with them fully. But you'll agree with me that if you are improperly constituted, then you cannot make one more step. It's therefore in that request that my Lord Judge Mrima asked, how do we move forward? I also had my learned mentor, Professor Gideon Muigai, again ask, how do we move in an orderly manner? I'm suggesting let that substantive application be placed before you. Being as preliminary as it appears on the face of it, give back-to-back timelines on the compliance by the parties. Let the parties come and now formally address you on that question. Let us have a determination on that question. I humbly plead.
Leadership again now, how to move forward.
Speaking for too long. Thank you. Allow me, my lord and my lady, to address the issue of disclosure, which is actually being attributed to Mr. Justice Mrima. And sometimes it's good to tell the truth, because the issue of how this bench was empaneled has not come to light just now. The actually view of it, they would have found out the letter which was written this morning, which it was written on the 20th of October, as actually one pertinent question. It is posing whether the file was actually taken to the Chief Justice and at what time. So they are actually knowing something regarding that. Then we are dealing with constitutional functions under Article 165(4), which means they were saying only the Chief Justice can constitute this bench. So they actually knew how the bench was constituted, and possibly the only reason we should be given is why the file was taken to DCJ, possibly because of the absence of the Chief Justice. They will have to take themselves to why we have the Chief Justice being the head of the judiciary and the Deputy Chief Justice being the deputy head of the judiciary. In the absence, that's what the Constitution provides. In the absence of the Chief Justice, it is the Deputy Chief Justice who is supposed to do administrative work, which, and here, let's not filibuster what we were told, that as we do in the Parliament, to go around in circles to waste time so that the motion possibly is defeated by a fluxion of time, which is what they are trying to do. The truth is this: it is well known in practice that the court's administrative functions can be done at any time of the day, including this bench can sit up to midnight without anybody questioning. So the issue of when the Chief Justice, Deputy Chief Justice sat does not arise. As to what happened on Saturday, again, this is purely administrative.
For the Speaker of the Senate, may we be heard? Yes. My Lord, allow me to assist the court. And my Lord, listening to the speech, not an application made by my colleagues on the petitioner side, my Lord, I just want to state that the Deputy President filed his petition on Friday, and my Lord, on the same day he got conservatory orders. My Lord, he accessed justice in accordance with the framework in Article 48 of the Constitution. But my Lord, justice cuts both ways. My Lord, the respondents on the same day filed an application to set aside those conservatory orders. My Lord, properly constituted, this court has issued directions that those applications be heard today. My Lord, under the Mutunga rules, there is a fundamental doctrine which we are all missing. The doctrine of timely resolution of such kind of disputes, especially disputes that are of immense public interest. So, my Lord, if you look at the application which has been made, or speech made by the petitioners, my Lord, you will see that they want to split hairs. My Lord, the Constitution expressly provides that the Chief Justice shall appoint a bench to sit on matters which raise substantial questions of law. But my Lord, at the same time, that Constitution which requires to be read conjunctively says the Deputy Chief Justice shall deputize the Chief Justice. So my Lord, what is the fuss about it? So my Lord, my request is that the application, this speech by the petitioners is solely meant to delay the business of the day. And my Lord, I request in public interest, my Lord, I request in public interest that you give directions. We proceed with the application. We are here to respond the application for conservatory orders. And my Lord, you also hear our application to set aside the conservatory orders. My Lord, that will make juridical sense and promote public interest. Thank you.
My Lord, if I may just add, this court has the control of the proceedings. And this is a very weighty matter. It concerns the Deputy President of this country. I will not allow everybody to speak, because if everybody is going to speak, we are going to head nowhere. A challenge has been posed on the validity of this bench to sit. This is the direction we are making. The application challenging the validity of this court to sit must be filed within 1 hour and responded to within 1 hour. We will come at 2 to listen to that application.
hapo kulikuwa ni mahakamani Milimani ambapo hatma ya Gachagua kotini ilikuwa inasikilizwa, na bila shaka imekuwa ni muda wa taifa kuweza